Welcome back to the Deep Dive. This deep dive is adapted from a clinician-written article on Mentalyc and brought to life in audio for therapists who prefer listening on the go.
And this is a really critical piece. It focuses on documentation as a legal shield. And it was written by Sylvie Saxena, that's MBA, LSW.
Yeah, she has such a great background for this. A licensed social worker, a certified clinical trauma professional. She brings this really grounded perspective on complex medical and psychosocial concerns, which, I mean, that's the daily reality for so many of us, right?
It absolutely is. And since the article comes from them, it's probably helpful to know that Mentalyc is a clinical intelligence platform. It's designed to support therapists specifically with documentation.
Which is exactly what we're talking about today. So I want to start, right at the heart of the problem. That moment after a really difficult high-stakes session.
Yeah.
Maybe you've just done a high-risk assessment or a painful termination, maybe even a really sensitive informed consent discussion. You finally close the door, you look at the clock.
And you know you have to get it all down. The nuance, the rationale.
But the details are already starting to get a little fuzzy.
Yes. That gap, that little bit of time between the session ending and the note actually starting, that's it. That's where we inadvertently open ourselves up to our first major legal vulnerability.
And that's a perfect place to start. Because the core idea here, the main insight from the article, is that we have to sort of fundamentally shift how we see documentation.
We do. It's not just an administrative chore. It's not just paperwork.
Right.
We have to view it as the single most important piece of legal evidence we have. Evidence that we've met the professional standard of care.
So even if your clinical work was perfect, if the documentation is weak, legally speaking.
The documentation wins. Poor notes aren't just sloppy, They are a deviation from the standard, and that carries some pretty severe legal risk.
Okay, so let's unpack that legal risk, because the article lays out these 4 pillars that a client has to prove for a malpractice claim to be successful.
And documentation is absolutely central to defending against every single one of them.
Okay.
So to prove negligence, they have to establish 4 things. First one's easy, duty of care.
Right. You took them on as a client. The professional relationship exists. It's a formality. The record is there.
Exactly. But the next 3, that's where your documentation becomes either your armor or, your Achilles heel. Second is breach of duty. So did you fail to meet the accepted standard of care? Your notes have to proactively prove you didn't breach it.
Give me an example of that.
Okay, say you have a boundary challenge in a session and you're required to consult. If you don't document that consultation.
It suggests the breach occurred.
Strongly suggests it, yeah.
Oh.
Or if you don't document your rationale for a decision to discharge a client, the lack of documentation speaks volumes.
So let me drill down on that. Let's say I conduct a really thorough risk assessment, but I don't document the rationale for my decision, why I chose not to hospitalize the client.
Okay.
Does the assessment itself still protect me, or am I exposed?
You are highly exposed. And that's because of the third pillar, causation. The plaintiff has to prove that your action or your lack of a documented action directly caused harm. So your notes might show you assessed risk, but if they don't show why you decided the client was safe to go home, the clinical reasoning, the safety plan, the steps you took to mitigate risk.
Then opposing counsel can just argue that the harm was caused by that undocumented judgment call.
Precisely. The documentation itself becomes the measurable action that you took.
Wow.
And the final pillar, damages, is just about whether the client suffered measurable harm as a result. So if you miss documenting those critical informed consent talks or the treatment plans or those danger evaluations,
But those become the weak points.
they become the pivotal points that make it nearly impossible to refute claims in court.
Because without that clear trail, electronic or paper, it immediately becomes a he said, she said scenario.
And the professional mantra is true. If it wasn't documented, it wasn't done.
Which brings us to structure and timeliness. The article really stresses using structured templates, SO, DAP, BIRP, whatever you use.
And getting those notes done promptly.
And that's not just about being organized.
No, it's a compliance necessity. Structure proves you covered all the clinical bases, and promptness ensures accuracy before your memory starts to distort things.
But promptness is such a huge pressure point, isn't it? Especially with heavy caseloads. I mean, we often feel like we have to choose.
You do. Am I fully present in the session, or am I busy scribbling notes to make sure I capture the details later?
Exactly. It's a real-world trade-off.
And that's why supportive technology is becoming so essential. The article points to tools like the AI note taker and its role.
How does that help with the specific problem?
Well, it helps capture and structure the content of the session so you, the clinician, aren't diverting your attention to physically taking notes during the session.
So right after, you've got structured content ready to go.
Exactly. It's ready for your review and finalization. It directly mitigates those legal threats that come from, poor memory and lag time. It helps you be prompt.
Okay, so moving beyond malpractice for a second, there are also licensing board complaints. And those are serious. They can lead to disciplinary action, fines, even suspension.
And licensing boards are incredibly thorough. They focus so heavily on the continuity of care.
What are the common documentation failures they look for?
The big ones are missing treatment plans, any failure to maintain confidentiality, and, again, a lack of documentation showing you took risk management steps, suicidality, child abuse reporting. You have to show your work.
And these requirements are not just vague guidelines. The article reminds us we have to know our specific state mandates.
Absolutely. The source gives some great examples. Like in California, the mandate is to keep records for at least 7 years after the last client contact.
Right.
And in Texas, the board explicitly requires documented treatment plans, demonstrable client progress, and clear notes on any ethical considerations you made.
So these are specific rules that need specific documentation. And those demands, especially around the plan and the progress, that's not just for the boards, that's critical for insurance companies too.
Oh, absolutely. If your documentation doesn't clearly justify medical necessity, you're looking at claim denials, painful audits, and in really severe cases, even potential charges under the False Claims Act.
And that's where we hear about the golden thread.
Right. Yes, the golden thread is paramount. Your documentation has to show this seamless, undeniable link between the initial assessment, the treatment plan, the progress notes, and then finally the billing code you used.
It's more than just checking boxes, though. An auditor is looking for clinical substance. What does the documentation actually have to show?
It has to link the client's progress directly back to the goals in the treatment plan. So if a goal is, say, client will utilize 3 grounding techniques when anxious, your progress note can't just say they did it. It has to reflect how that impacted their symptoms and why the intervention is still medically necessary. That's where tools like the AI Treatment Planner and the AI Progress Tracker can be so helpful.
They help systematize that narrative.
Right. They help make sure that documentation consistently justifies the medical necessity and shows the client is moving forward. It's your strongest defense against claim denials.
That structural support ensures you don't accidentally break that thread just because you were rushed or tired.
Exactly. And, while we're on legal requirements, we can't forget the most fundamental one. Confidentiality.
IPA, of course.
IPA, which demands secure storage, but also more stringent rules like 42 CFR Part 2. That puts additional highly protected layers around substance abuse treatment records.
And that has very real-world implications. It means we have to worry about leaving a physical file out on a desk or not encrypting an email or even just throwing away old paper files improperly.
It does. And with 42 CFR Part 2 specifically, the release of those records is so much more complex than a standard high-pay release. You need specific consents that detail exactly who gets the information and why.
Wow.
And if you mix that data with standard mental health data, you risk violating the stricter rules by default. Poorly kept files are a direct path to some very expensive violations.
Quick pause. If juggling comprehensive documentation and timely note writing feels familiar, Mentalyc can help. Its AI note taker supports your documentation process and clinical judgment while staying fully IPA and SOC2 compliant. You can explore it at Mentalyc.com. So we've covered a lot of the risks in weak documentation, but the article also gives us a really robust set of proactive defense strategies.
Yes, shifting from just reacting to threats to actively building protection into our workflow.
And the first step outlined is one we should all be doing anyway. Regular peer consultation and supervision.
It's essential, and it's not just for clinical growth. It is a critical legal shield.
Okay, how does documented consultation specifically act as a legal shield?
It reduces the risk of what's called clinical decision-making isolation. So if you're ever audited or sued, the fact that you documented seeking guidance from colleagues proves you are adhering to ethical standards, APA, NASWACA, whichever you follow.
You weren't just making high-stakes decisions in a vacuum.
Exactly. You are following best practice by consulting. And that process also helps with the second proactive step, periodic self-audits.
What should a clinician be looking for in a self-audit?
It's about accountability. You're checking for consistency. Are all your notes dated? Are all the required signatures there, especially on informed consent? Do your notes align with your retention policy?
You're catching a pattern before it becomes a problem.
Right. Catching a pattern of missing dates yourself prevents it from becoming evidence of negligence in a board investigation.
Which moves us to the safety net.
Yeah.
Malpractice insurance.
Absolutely essential. It's the foundation. But today's practice requires modern coverage. You need to look for policies that include coverage for licensing board defense.
Because those complaints are often more common than lawsuits.
They are. And you also need coverage that explicitly addresses things like EHR data breaches and teletherapy. These are the modern pressure points.
And this brings us to a deeper point the article makes. Connecting this proactive documentation to actual clinical efficacy. It argues that good notes aren't just for compliance, they actively improve client care.
They do.
Yeah.
Because when your notes are robust, they reflect true clinical judgment. This is where the source brings in a tool like Alliance Genie.
Which is a supportive reflection tool.
Right. It tracks subtle alliance signals across sessions. So this isn't about charting symptoms. It's about surfacing those crucial interpersonal dynamics that are happening.
So the reflection part is key. The tool helps you maintain strong ethical standards by maybe illuminating a potential rupture or a shift in the relationship that you might have missed in the moment.
Precisely. You know, a note might just say, client was passive today. That's pretty thin. But if you use a reflection tool and realize that passivity happened right after a rupture you didn't address, then you can capture that dynamic and your rationale for how you're handling it. It helps you document the why. And that clinical reasoning is your ultimate legal defense.
Integrating that deep professional reflection right into the documentation process. That feels like the next step in ethical practice.
It really is.
So as we wrap up this deep dive, let's leave you with one practical takeaway, something you can implement today.
I think the single most actionable defense is just adopting structure and consistency, especially for high-stakes interactions. Commit to a structured format, like SOP, for every single entry.
No matter how simple the session felt.
Right. And crucially, make an ironclad commitment to documenting critical assessments, risk assessments, informed consent, termination discussions immediately after the session. Don't let those high-risk details fade.
That focus on consistency is so key. Proper documentation isn't just about legal protection. It actively improves client care. It provides that traceable record of your rationale and their progress.
And that ensures your clinical judgment is supported by clear evidence. It protects both you and your client.
If you maintain that golden thread and you document your reasoning,
you're practicing defensive medicine in the best possible sense of the word.
If you want support in ensuring your documentation captures crucial clinical dynamics and alliance patterns across sessions, Alliance Genie can help you reflect on these signals without storing any recordings. Thank you for joining us for this crucial deep dive into protecting your practice.
We encourage you to continue exploring resources to keep your practice grounded and compliant.